Welcome, and we're live broadcasting through Noticiero Telemundo, Facebook, Twitter, Periscope, and all the social media, YouTube as well. Nice to have you. Nice to have you joining us today, and thank you again for your attention and your time. There are a couple of topics I want to touch on today. One is very important. It just happened yesterday. The other I'll touch maybe halfway through the broadcast today after taking some of your questions, both important topics. The first one is there's a new form that USCIS, the Immigration Service, the benefits section of the Immigration Service, has introduced yesterday. It's called the Form I-485. It already exists. They've modified it. They've amended it. It's effective as of yesterday. However, you can still use this form, and I'll explain what it's for and what the differences are in a minute. But I don't want to forget that if you've already gone to an attorney or you've already filled it out and you just sent it in the mail yesterday and you're worried that it's not going to get there for 2 or 3 days and that they'll reject it, it's not going to happen. There's a 60-day grace period for this form. The I-485, which is the form you use to get a green card in the United States. There, you can get a green card before an immigration judge, you can get a green card at an American embassy in your home country, or you can get a green card within the United States. This form, I-485, is the form that was used to request immigration benefits in the U.S. It's been used forever and many decades. However, it's just been reformatted. It used to be 8 pages, 6 or 8. It is now 18 pages long. Right. So those of you that are going to fill this form out, now it's humongous. I have it here, and this is double-sided, and these are all the pages of the new form, and we printed it double-sided to save paper. So that's how extensive this new form is now. Immigration is saying that it's to be more efficient, that the officers will be able to approve applications and deny them, because there's a lot more information they can quickly check on this new form. So basically, 60 days grace period. So if you filled out and have already signed at your attorney's office or your own form, or you're sent it already in the mail today or yesterday, no problem, they'll accept it. But after, beginning August 25th of this year, 2017, this form will no longer be accepted, the one that's the old one, and it has a date of, I believe, January 17, 2017. The new form has a date of June 26, 2017. So this form can be used now if you have it, and you can download it at uscis.gov, and the forms are free. Or you can use the old one until August 2000, this year, August 25th, 2017. What is this form for? It's a form to apply for permanent residence. It's called adjustment of status. And not everyone can immigrate here. Of course, nobody wants to go before an immigration judge in a court and in a trial to immigrate. Nobody wants to have to leave the United States to maybe get a green card or maybe be left out of the country for 10 years. There are punishments now that are applied in many cases for people that have lived here out of status. So everybody wants to attempt to immigrate here. So if you are able to adjust status because you came in legally, you have children that are in the military and they're going to petition for you and they're over 21, you have a protection of an old law 245I, you are a victim of a violent crime and a U visa, then you're going to immigrate here. You are a victim of domestic violence by an American citizen or a resident, you're going to self-petition. You're a widower of a U.S. citizen, you're going to self-petition. This is the form that is used. You are granted asylum. A year later, you're going to apply for your green card through asylum. This is the form you're using. So as you can see, this form can be used for a number of methods to get a green card within the U.S. So very important. They didn't say the fee was going up, thank goodness, because it's expensive. However, the form will change. So if you're going to file this application, my recommendation as an attorney with decades of experience is why not use the new one, However, if you have a lawyer, look at both. Why? Because the old form has a lot less information, and in some cases, not that you're going to lie, but you don't want to blatantly show certain information to immigration that might cause problems in your application. So a lawyer will look at your case and say, in your case, it doesn't matter which application we use the new form. If the new form discloses a lot more information that puts you in a light Again, not that we're omitting information, not that you're lying, but that perhaps opens up a window of doubt in your application, and you might get a request for more evidence and the case will take longer only because you're using the new form, whereas the old form wouldn't have shed that negative light or suspicion on you and you'd get approved. Of course, go with the old one. So many applications are being revamped under this new administration. The citizenship one I talked about probably in the Spanish version of this Facebook Live, or formerly called Facebook Live. And we talked about how it was also a few pages long, and now it's 20 pages long for citizenship as well. So the new applications, of course, they're more complete, they're longer, they're supposed to be easier to fill out, but they ask for so much more information. So before sending it out, before doing anything with immigration, always seek the advice of a competent immigration attorney. Again, many people say, but I can't afford one. At least pay one consultation and see a lawyer and explain what you're trying to do, show him what you're doing, and then hopefully the lawyer will say, you're on the right course, go ahead, or don't file it because they see something that's negative and could prejudice you. Remember, this application, I-485, to get a green card within the United States, has only two avenues at the end of the tunnel. The immigration officer would either say, welcome to the United States, your case has been approved, you are now a lawful permanent resident and expect your green card in the mail. Or they can say, well, three things. They can say, we need more evidence, we're going to investigate this. Or lastly, you're denied and expect a letter from an immigration court for an immigration hearing before a deportation judge to decide if you should stay or you're leaving the United States. So again, my interest here is always to be positive, to always give you tips and strategies on how to improve your chances of getting legalized, becoming a citizen, avoiding deportation. But I also have to be realistic, and I also have to tell you what is, and what is that the immigration officer can quickly decide a yay or a nay, and lack of preparation, lack of adequate advisement by an immigration attorney can have huge, profound influence or a negative determination. So again, seek counsel. Let's start with the questions because the other topic's really important too, about people using fake social security numbers and the consequences of that and what they're going to do with this new finding of a study that was recently done. So don't miss that. Let's start with your questions.
The first question is from Tere Chacon. If my husband gets paid cash and doesn't do his taxes, can I help him get his papers?
Sure. Actually, I really like that question for a number of reasons. In the past, if you were going to get a green card, say I was going to get a green card through whatever method, I had to show that I make enough money, that I have a bank account, that I pay my taxes, that I have an employment letter, that I make a certain amount of money, that I'm not going to be a public charge, but through my own resources. Immigration got smart a few years ago and they said, no. We don't want to know the person, the foreigner. We want to know the United States citizen or the resident that is petitioning for someone. We want to know if that person pays taxes, has a bank account, has real property, how much he makes, has a full-time job, and makes above a certain amount to be able to petition for someone. So congratulations. The fact that your husband hasn't paid taxes, gets cash only, is not relevant. They do want to know how much you make, in this case, Ms. Chacon. They want to see, do you work? Do you make a certain amount above the poverty level? And can you prove that with your taxes? So things have shifted.
Renieri Ortiz. My question is, how long does it take to approve or receive a response for a waiver I-601 or an I-212? I was deported 8 years ago, and I'm waiting for those two waivers to be approved in order to get my green card. I'm currently in Lima, Peru.
Okay. I love this question because just yesterday in my office, one of my lawyers came to me and said, great news, we just got an approval on an I-601 waiver, and it only took 4 months. I mentioned, I think a week or two ago, that everything is backlogged at USCIS and it's taking a lot longer to get approvals. Well, for some reason, the waivers for illegal presence, the I-601A, are now some, not all, depends on how well prepared the case is. If you give a well-prepared application with supporting documents to USCIS, they're going to look at it and say everything's here, approved. If it's poorly prepared, it's going to take longer, or they're going to ask you for more information. But if the application is well prepared and has everything the immigration officer needs to make a decision, it's taking 4.5 months right now for the I-601. You also ask for an I-212. That's an application for a waiver for people that have had prior deportations. Those are taking a little bit longer, and I've seen some as fast as 6 months, some as long as a year. The fact that you're in Peru doesn't make a difference because they're not approved. Usually they're approved by the Immigration Service at the American Embassy in Lima, Peru. They have sometimes immigration officers in the embassy, or they're shipped out to Mexico City or different parts of the United States so that an officer can make a decision. You can check the status online at uscis.gov, so make sure you're checking just to see how it's trailing along. And your lawyer can also file an inquiry in written form just to sort of remind them what's going on with that application. We're on top of this, so they don't forget, and hopefully they approve it in a little more faster time or more expeditiously.
All right, the next question, I hope I'm not butchering the name here, is Ildiko Biksok. I wanted to know, if someone applies for a discrimination asylum and this person is coming here legally for 8 months, do they have a chance to receive the papers? They're coming from Romania.
Okay, but you didn't tell me what kind of visa. It's already been approved. Remember, a visa gets approved at the American Embassy, but then a CBP, a Customs and Border Protection officer at the airport, off a ship or in a land port, will decide if you're eligible to be admitted or not. So I need a little more information, and thank you so much for tuning into this, and please tell all your friends. This is why Telemundo and myself are doing this, to give immigration information, basic immigration information to everybody that needs it, not just Spanish speaking. So if you're going to write me again, I would love to hear your question. A little parentheses, if you do write again, we'll save it. Next Tuesday is 4th of July. 4th of July, of course, many of you may know, and some of you that are watching from other countries, it's the National Independence Day of the United States of America. So 4th of July is a very important holiday, and we are going to be dark, so I will not be here. I would love to be here, but there's a big team, and as a team, we're not going to be here. It'll be dark. So just letting you know, it doesn't mean that this is canceled. It just means that next Tuesday, is 4th of July. So we will come back in 2 Tuesdays. So please send me a little bit more information, person from Romania, and I'd be happy to follow up on that answer.
Roger S. What else can we do if the TPS will not be renewed? I don't have any children or any close relatives who are citizens.
Well, it depends on when you entered, how old you were, and how long you were here out of status before you got TPS. Some people arrived shortly before applying, or they arrived as children. When they turned 18, they got TPS, so they have no illegal presence. So maybe an employer wants to help you immigrate because of what you do. So again, consultation with an immigration attorney, not one but two, to see if maybe there's a possibility through what you do. A lawyer would talk to your employer to see if the employer qualifies to petition for you, if your job qualifies, if you qualify. So it's very important. Now is the time to do preparatory, I call them footsteps, before we hear the bad news that TPS might be canceled for Central America. Until now, those of you that are tuning in for the first time, I don't want to get anybody worried. TPS is still alive and well for Central America, only for Haiti. They've given us a brief extension of 6 months, and after that, they're canceling it. But very good question, because many people have had TPS for a decade or more, and they've gotten comfortable. They keep renewing it every 18 months, and they haven't looked for other alternatives, or they even have family that can petition for them, or maybe they've been a victim of a violent crime and they can apply for a U visa. So now is the time, everyone, if you have something that's just been recurring, and every year you get a work permit, or every 18 months, it's time to stop that with this new administration and look and see if there's an alternative for you.
Jonathan Sanchez. I renewed my DACA a couple of months ago and didn't receive my employment authorization card. How long does it take for them to send a new card?
It's taking a long time now. When it started, the program, I remember within a month or 2 months, I was getting work authorizations and approvals on DACA. Now it's taking 5, 6 months. So be patient. That is, they're receiving less applications. Maybe they've outsourced some of the personnel. And when it first started, they had so many that maybe they brought in personnel. I'm not sure exactly why, but it's taking now up to 6 months to get a new work permit for a renewal for Dreamers through DACA.
Elsa Herrera Ortiz. My husband received the I-601 waiver approval and it came in about a month ago. Yay. Does that mean his residency card is guaranteed?
Oh, no. I love the questions today. They're very, very important questions, and I'll answer, but they're also very educational about the process itself. So thank you for that question. An I-601 waiver, it's an application that is filed because you've lived in this country out of status. You either came in illegally or you came in with a visa and you overstayed and you've had years or months of illegal presence and you had to ask for this waiver, and maybe your wife is a U.S. citizen or your husband and they're petitioning for you, you need to ask for this waiver. That waives one thing: illegal presence, the fact that you've been here illegally for a certain amount of time. It does not waive anything else. You heard the question of the gentleman from Lima, Peru. He said, I'm asking for 2 waivers. If the I-601 pardoned everything, people wouldn't be asking 2 waivers. You have to ask for different waivers for different things. That's why a consultation with a competent immigration lawyer is important, so that he or she can say, wait a minute, you've got this, you've got this, you've got this, and you're going to need waivers. And you do it all at once. And you do it in a strategy or strategic manner so that they're timed appropriately. Whereas some people ask for 1 waiver, they go to the embassy and the consul says, oh, you also have, we caught you once with a fake green card, or you were stopped by the police with a fake social security or fake driver's license. Oh, or you had a shoplifting offense, or oh, you have a certain crime in your past, or you were deported. There are so many bases that immigration, they have literally a roster, like a clipboard when you go to the American embassy, and they're checking point by point to make sure you are admissible, means that you can be granted a green card. And if you don't check every one of those, you may be inadmissible and they'll deny you. And guess what? You're not in the US anymore, your lawyer's not there, you're by yourself, and there's very little recourse usually at the American embassies. So you do not want to leave this country until a lawyer has looked at your entire packet, made sure what you may have in your background that may cause a consul to deny you. And if there is a waiver, file it and then postpone your interview and then go with several waivers in hand if that's what your case requires. So excellent question.
Aide Hernandez. I'm a permanent resident and I would like to become a citizen, but I have a DUI. Would this be a problem?
Very important, and I have friends that watch me and you use your hands so much. I have to in this example because I don't have a whiteboard to share information with you or a pin of any sort. Immigration, when you're becoming a citizen, you're a green card holder, they'll look at the day you got a green card and they'll say for 5 years you have to have been good. If you had any crimes in the first 5 years, you're going to be looked at and you may be denied. Also, they'll look at today and they'll look at 5 years before that. And they'll say, wait, do you have any crimes in the last 5 years? You don't tell me where in this spectrum of time, this ruler of time, you had that DUI. If you're still on probation and it was recently, don't even apply. You're going to get denied. You have to be off probation. If it was in the last 5 years, it may affect you, but you also don't tell me what kind of DUI. Some people get stopped for a DUI, and unfortunately, they haven't hurt anybody. They haven't been stopped and flee the scene. They haven't had an accident. They haven't destroyed public property of any sort or hit other cars. So it's a simple DUI. Other people have DUIs and they rise to a level of a felony, or they've had several. So the first thing is get your record for the DUI, take it to a lawyer, let them see that DUI and and your green card, so the lawyer can see when you got your green card, when you got your DUI, when you want to apply. I've seen people in my office that I say, I see you had this here in the spectrum. We have to wait 1 year, 2 years, 3 years, 4 years before you can apply for citizenship. So you don't want to waste your money on the application, And you don't want immigration to spot you and say, oh, now we know that you had priors and you have a green card. Maybe we want to tell the judge to see you and maybe try to take your green card away. So be very careful before applying for citizenship. I totally endorse people becoming citizens, but check before you file. Our second topic is, there's an article in La Opinión, and it was in Spanish, but I'll translate as I'm talking to you. And basically, it was a study performed. And the study shows, the IRS made the study, that 1.4 million people that are undocumented use Social Securities that are either made up, they saw a friend's card and they use the number, but they're not theirs, they're not valid numbers, or they're made up, or they belong to somebody else. So basically what the IRS said with this information, they also calculated that 2.4 million people pay taxes that are not documented in this country, and they use an ITIN number. That's a number the IRS gives you to pay your taxes. It's not a number to work. It's not a Social Security number. So a Social Security has two purposes. You can show it to an employer and work legally in the United States, and you can use it to pay your taxes. An ITIN number, which is a temporary number the IRS gives, and it's an ID number, is not, you can't show it to an employer and get a job, but you can't pay your taxes. So 2.4 million people that are in this country undocumented are paying taxes with this ITIN number and not getting any reimbursements, but at least they're filing their taxes. If there's ever an amnesty, they'd have proof that they've been here for a certain amount of years because they've been filing their taxes. So what the IRS said they're going to do with this study, and this is why I'm sharing it with you, if you know someone that is using a Social Security number that is not their own, that is used inappropriately or they've made up, they're saying that they're going to now figure out a way, they're starting a pilot program, the IRS, to let people that have a valid Social Security number know that X person is using your number illegally. So if I'm a US citizen and somebody's using my Social Security number, they made it up and it happens to be mine, I don't even know this. But now the IRS is going to start letting people that own the valid number know that somebody is using it inappropriately. And of course, with that information out, my next thought would be that people would be able to sue individuals that are using the number, or that somebody that's using a number could be criminally convicted. So very important, again, not with a purpose of alarming people that are watching this, but if there's a way that you can seek advice and find a way of getting a green card and not have to use these fake numbers, now is the time. Under this administration, under all these changes that are happening now, and this is another one of them that is meant to protect U.S. citizens and residents that have valid numbers, but it will hurt those that are using them illicitly, and not to commit a crime, just to work and pay their taxes, but that could be in certain states a serious crime if you're convicted of it. And then later, when you want to get a green card, it's going to be in your record. So seek advice. Let's go back to questions.
Carrie Castillo. My case was approved by the I-130, but I enter illegally to the U.S. Can I do the waiver myself?
Ooh, another very good question. Today, again, this is one of the first sessions we've had where question after question is amazing and outstanding. Thank you. Yes, you can file a waiver, an I-601 or any kind of waiver on your own. I'm not going to lie to you. Oh, you only need a lawyer. That's not true. I'd be lying to you. I can file my own taxes. I never do. I use my accountant. I use a CPA to review what the accountant did because they're serious. If you make a mistake, the IRS is no fun to deal with. Same thing with immigration. If a mistake is made, it's going to take longer. It's going to cost more. I-601 waivers on a national level are approved 50% roughly of the applications. So if they get 1,000 applications a month, let's just say, I'm making the number up, but just to illustrate my example, only 500 of those waivers get approved and 500 get denied. With those odds, I don't think I would want to file my own waiver. I would want to seek counsel that knows how to prepare them and prepares them in a way that is highly convincing to the immigration officer that you deserve to be pardoned. So you have to show extreme hardship to the U.S. citizen or lawful permanent resident that's petitioning for you, or if you have a mother or father that's a resident or citizen, or if you have a spouse that's a resident or citizen. Those are the qualifying relatives to file an I-601 waiver. And if they're well and healthy, it's going to be really hard to win an I-601 waiver. The I-130 is a piece of cake. I always say a child can fill it out, but not a waiver. I recommend seeking advice.
Delmi Gallardo. I have a visa U, however I got married last year in 2016. Next year I have to make the adjustment of my husband's illegal status. I would like to know what's the process to add it to my case. Should we apply for the I-929? Do I need to leave the country?
Okay. The U visa, for those that are watching us for the first time or don't understand what a U visa is, for victims of violent crimes. Congress made this law years ago, and if you're a victim of a violent crime in the United States and you've reported it, you can file for a green card, and it's called a U visa. Now, you tell me that you've already been approved. There are two places in the timeline of getting a U visa green card where you can add a spouse. You can add it at the beginning when the U visa is filed, or once a U visa is approved, you can add it 3 years later when you file for your adjustment of status. Remember I talked about a new form, the I-45, that's starting yesterday? Well, that's the form that's going to be used for you, in this case, that got the U visa, and you would file one for your husband. You don't have to redo the U visa all over again. So don't let lawyers tell you that you do. It's a way of charging you more money. You can just add him at the end. So my advice is for your husband and you to go see your lawyer that did the U visa to make sure your husband's eligible to get a green card as well. You don't want to turn him into the system because he's eligible to be added by you, but he's got something in his background that may render him ineligible.
Jonathan Marin. My wife has DACA and we got approved for advanced parole. We went to Tijuana to visit her mother who was ill. When we returned, we signed her form to change her status. I'm a U.S. citizen and I would like to know how soon she can receive her residency if I request her.
I love this story because so many dreamers have families still back home, and people get sick. They're elderly, or somebody might get sick or have an accident or need surgery, and they're afraid to leave the country. Again, seek advice before you go. But if you are brave and you are eligible and you do get an advanced parole, you leave and you come back legally. And in this case, because she's married to a United States citizen, now they can file the last process called an adjustment of status, and it takes a mere 5 to 6 months to get a green card in the U.S. without having to go to the American Embassy abroad. Congratulations.
Mayra Guerrero. I'm a resident. Should I wait 2 years to become a citizen or apply for my husband as a resident?
So you've been a resident, I assume, for 3 years, and you have 2 more to go to become a citizen. I don't know what country your husband is from. The waits are different for different parts of the world. Under this new administration and the way things are, if I was that permanent resident, I'm going to put myself in your shoes. I'm the wife. I have a green card. My husband doesn't have any way of immigrating but through me. I wouldn't want my husband walking around in this time and date without any protection. I would want to file for him, file the I-130. Not that it's a visa, not that it's a permit, not that it's a work permit, but at least I've started something for him. And then once I become a citizen, and once I'm naturalized and have my naturalization certificate, I let immigration know that my status has changed, and then I can proceed to finish the case. If he entered legally in the United States, I'd file an adjustment of status and it would be quick, or then pursue the last phase, which might be a waiver, the National Visa Center, and the American Embassy abroad in his home country. It doesn't hurt either way. I would just like to feel now, if I'm that person, the man in this case that is totally out of status under all the things that are happening in the news today, is that at least something has been filed on my behalf.
Edgar Gudino. I got married to a U.S. citizen and we have a newborn child who's also a citizen. How can they claim me?
Well, the newborn child cannot apply for you. We're talking in the 50s or somewhere around there. There was a law that if you had a child born in the U.S., you could immigrate. That baby could somehow petition for its parents. That's been gone a long decades and decades ago. That child now has to be 21 to petition for you. But your husband is a citizen. Your husband can apply for you. You don't tell me how you entered, if you entered legally or not, or if your husband was in the military or is still in the military, so that you could immigrate here. But that's an analysis that has to be done by an immigration attorney in person or over the phone with you to decide which is the best recourse. But your husband can definitely petition for you.
The next question is from Blanca Salmeron. She says, my husband has 2 DUIs. Can he fill out the application? He has a criminal lawyer, and we're waiting to see what happens. But I would like to know if he should fill out the application or if he should wait. Now, Alma, I'm not sure if she's referring to a residency application or citizenship, but I'm sure you can answer generally.
Okay, I'll answer both because that's really important. And it's more and more common, unfortunately, that people are drinking and driving. Not that it hasn't happened before, but it seems to be happening a lot, and it might be, I'm not excusing it in any way, but the stress of, daily stress, as well as what's going on in the nation and a lot of the immigration negative news that's happening. However, DUIs can be prejudicial if you want to get a green card or if you want to become a citizen. So if you want to become a green card holder and you're not a green card, you're out of status and you're getting these DUIs, I would definitely not send you to your country to get a green card with 2 DUIs. I would want to do some work in conjunction with a criminal lawyer to see how those DUIs can be wiped out, pardoned, changed into a reckless driving, something different, so that the U.S. consul abroad does not see 2 DUIs. I don't send my clients to go try and get a green card to their home country at the American embassy. I send my clients to the embassy with a high probability of getting approved, and that sometimes means waiting or doing some additional work. Now, if this person has a green card and has 2 DUIs and wants to apply for citizenship, I don't think so. If he's going to get probation, you cannot apply for citizenship while you're under probation. So again, get those DUI records. They're called conviction records or docket sheets, and go see an immigration attorney to see if this is going to affect you in one or the other cases. Do not file anything until you've talked to an immigration attorney.
Edie's Bravo. I renewed my green card 3 months ago and went to get my fingerprints. I haven't received anything yet. How long does it take, more or less?
Not good news, Edie. It's taking right now up to 9 months. I've seen some magical cases in 3 to 4, but it's taking up to 9 months to get a new green card. Green cards used to be forever. Now they have an expiration date and they're good for 10 years. Not your green card, not your permanent resident status. That's for life unless you lose it. But the card, the actual manifestation of you being a green card holder, that lasts 10 years. So now every 10 years, and I recommend people renew them 6 months before they expire, and now it's taking anywhere from 6 months to almost a year in some cases. It depends on the fingerprints. It depends on what they find that you've done in the last 10 years. If you've had any crimes, it's going to take longer. So be patient.
Christian Guerrero. The CAM program for minors of Central America is on the move currently. I was accepted as a parolee. I did the medical exams, which is the last step, but they haven't called me since the last 90 days that they've been on strike. What should I do?
They haven't called you in the last 90 days? I'm sorry, I missed the last part. Oh, okay. Yeah, a lot of things are slowing down for a number of reasons, and unfortunately, I would recommend that you check the USCIS page and just check the status. I assume you have a lawyer doing this or a pro bono agency. There are many that are helping unaccompanied minors and people from Central America that came here. So my recommendation is that you contact the person that is assisting you in this so that they can file an inquiry, and that's the best thing to do. I know that there are variables that sometimes make cases take longer, but I don't like immigration forgetting my clients. I like to send an email, I like to make a phone call, I like to send a letter through the US mail and just say we're still waiting, what's going on, so that they pull that file and dedicate some time to it and hopefully give it some priority.
Thank you so much, and this is the last question from Eric Rosie Gonzalez. Is it better to apply for DACA than advanced parole to get a green card, or is it better to get the waiver?
Ooh, that's a loaded question. It's the last one, and it's a loaded question, so I'll try to answer it as best I can in the brief amount of time we have left. DACA, we don't know how long it's going to last. I hope forever, or I hope for many years until there's a substitute for it. The risk of getting an advance parole is that you may be out of the country and then this thing gets denied and canceled and you can't come back in. So that's always a risk, but it's the easiest way to come back legally, and then if you're married to a citizen, immigrate here. I call it the Rolls Royce of the processes because it's so simple, it's quick, it's less expensive, it's less risky. Now, the other alternative is filing a waiver because you've been here illegally and having to go out. Now, luckily, I send a lot of clients out all the time to go to their interviews at the embassy, but we've been working with them for years in the process, and we've done the waiver for them. I know their history, and I know that it's a good case, it's viable. My concern is that if you have anything in your background, you've been detained by immigration, you've been deported, you've had any crimes in the past, you even have tattoos on your body, all of those issues, or you've had illnesses that are communicable in the past, all of those issues could be used against you, and you can be denied at the American Embassy abroad. So as you can see, not that those things are not looked at in the U.S., but in the U.S., your lawyers here, we can ask for waivers. There's more fighting. You have a fighting chance in the U.S. When you're out, you're out. And if they say denied, in some cases you are denied, and that's all there is to it. So you have to do this, and that's where a good lawyer that is honest will look at your case and say, you know, this costs double, and it's not about me in my pocket, it's about you, and this costs half, and this is faster, and this is less risky, go this route. Or this costs a lot more money, but I'm afraid that they'll catch this and this here, and over here it might not be an issue, so maybe you should go this route. That's a legal analysis that has to be done one-on-one with a lawyer. I'm so glad you're asking the questions here to get basic general information, and hopefully I can be a little beacon of light so that now you can go seek counsel, and if they don't mention it, you can say, wait a minute, I heard, and how does that apply to me, or how does it, maybe it doesn't apply to me, and get more out of a consultation with an attorney. Best of luck. Remember, those of you that just tuned in, next Tuesday is 4th of July, Independence of the United States. We will be dark. We'll be back in 2 Tuesdays. And this Thursday, en español, lo mismo los jueves a las 7 de la noche, hora del oeste, y a las 10 de la noche, hora del este. So for those of you that speak both languages and still have questions, you can tune in this Thursday, 7 p.m. and 10 p.m. East Coast time. See you in a couple days. Thank you.